Now, can you hear my voice? Hello.
Yes, Miss.
Okay, so this morning we had started with our course outline, and then we have start to learn about topic 1, which is on the sources of law, and then we stopped at one of the sources of law. Okay, so before we continue, apa tadi kat sini? Okay, so before we continue, let us recap what we had learned this morning. Okay, so what are the difference between written law and unwritten law? What are the difference between written law and unwritten law? Suara hilang lagi. Hello?
Miss? Hello, Miss?
Can you hear my voice? Is it clear?
Yes, Miss.
Okay. So what are the between written law and unwritten law?
Miss?
Mm-hmm.
Okay, written laws are laws which have been enacted in the constitution or in legislation. Unwritten laws are which are not contained in any statutes and can be found in case decisions. Maybe in the first law.
Okay.
Mhm.
Okay. So that is correct. So written law are or made by the legislative assembly. So any other types of law like custom law, all of them are considered under unwritten law because it is not in the statute. So if it is in the statute, it is called written law. But if it is not in the act, not in the enactment, not in any statute, it is what we call unwritten law. Okay, and then what is federal constitution? Can anyone give a brief summary about what is federal constitution? What's the importance of federal constitution?
Uh, Miss?
Mm-hmm.
Yes, Miss. So the federal constitution is to enact any law and also legislate the laws that exist in our nation.
Mm-hmm. But the most important feature of the federal constitution is
Oh, most important feature.
what is the most important feature?
I don't think. Sorry, Miss. I'm afraid that's as far as I could.
The
Sorry.
most important feature of the federal constitution is it is the supreme law of Malaysia. So it is the highest law in Malaysia. If you want to make any law, you have to refer to the federal constitution first. If it is allowed under the federal constitution, then you can make the law. So the most important feature of the federal constitution, it is the highest law of the land, or what we call the supreme law of Malaysia. Okay, so that is federal constitution. Then state constitution, what is it?
Madam,
Mm-hmm.
state constitution is a law it's a law which possess in in states matters.
Mm-hmm. Mm-hmm.
So it's controlled by every states, each states.
Yes. So state constitution is the highest law in the state. So it is made by the state and it is the highest law in that state. So if you want to make any enactment, you have to refer to the state constitution first. So if you want to make an enactment, you have to refer to the federal constitution, make sure it is not against the federal constitution, and at the same time, you also have to refer to the state constitution to make sure that the law that you enact is not against the state constitution. So that is federal constitution and state constitution. Federal laws are acts, state laws are enactments. One more. What is subsidiary legislation? What do you understand about subsidiary legislation? What in the world is a subsidiary legislation? Who made the subsidiary legislation?
The minister, madam.
Minister. Oh. So how can the minister make a subsidiary legislation?
Especially on the detail lah, yang small.
Mm-hmm. Tadi orang A tadi tu siapa yang A tadi tak jawab, tak habis menjawab.
Saya miss.
Okay.
I wanted to say that the subsidiary legislation is done by the members of a ministry and in the cabinet.
Mm-hmm. Okay, so subsidiary legislation is a small laws which what we call, sometimes you call it a proclamation, sometimes you call it a regulation, sometimes you call it order, notification, bylaw or any other law instrument made by the ministry, and it is made under any law or any enactment or any ordinance. So usually it is under the act state in the law. I mean, it is stated in the act that the minister might have some kind of power to make certain types of certain kind of law under the parent act. So parent act, the parent law is what we call the act lah. So the parent law is what we call the act, and then under the act, usually have the power to make some kind of laws to execute whatever inside the parent act. So that is a subsidiary legislation. So basically, subsidiary legislation is something which is made by the ministry or any governmental bodies, not made by the parliament and not made by the state legislative assembly. Okay, one more, last one. What is judicial decisions?
From my point of view, it's a law that haven't have yet, and then it's up to you. It's up to the judge lah to assist the lawyer, especially for like the example of using of the drone, right?
Mm-hmm.
So there's no certain law that actually have been applied. So it's up to the what you call precedents, right?
Yes. Okay, so that is judicial decisions. So judicial decisions is usually made in two situations. One is when there is no law, like what I said during the morning class regarding drone, and someone use the drone to trespass into somebody's property. They use the drone to capture everything inside someone else's private property, and then there is no law regarding drone. So the court can make their own laws regarding drone, because there is no law regarding drone that has been made yet. That is one situation. The other situation is the court can also the court can also use judicial decisions in order to interpret law, because some laws which are made is quite general. The law might be general in application, or the law might be a bit vague. It doesn't specify things. So the court will usually interpret the law in order to make it more specific. So lawyers and everyone who is related to the legal world, they can refer to these decisions in order to understand what the act is all about. So that is judicial decisions. We finish until here during this morning. So we'll continue with the next source of law, which is English law. So, the Civil Law Act 1956, we have an act called the Civil Law Act 1956. This act provides for the application of English common law. So, according to the Civil Law Act 1956, we can apply English law. So when we talk about English law, we are talking about the law which is enacted in the UK law. So it is applicable in Malaysia. Why do we think so? Why does Malaysia apply the laws that are being enacted in England?
Is it because Malaysia before this being what they say controlled by the UK?
Yes, because our country used to be under the administration of British before we got our independence in 1957. That is why the English law is also applicable in Malaysia. Because of that, because we used to be their what we call jajahan British. I can't remember what they did in English. But because we used to be under under the British administration, that's why some of the English law is also applicable in Malaysia. But yes, but there are some cut-off date, which means that we can use English law, but we cannot use the latest English law. There is a cut-off date, as mentioned in Section 3 of the Civil Law Act 1956. We can use English law in Peninsular Malaysia up to 7th April 1956. So any law enacted before 7th April 1956 can be used in Malaysia, is binding in Malaysia. And then any English law which is made before 1st December 1951 is applicable in Sabah, while any English law made before 12th December 1949 is applicable in Sarawak. So that there is for using the English common law. So the current English common law is no longer binding. You can refer to English law, current English law, but it is only what we call persuasive. So you can use it as a reference, but it is not binding. So you can refer to English law whenever you want to argue a case. You can refer to English law, but it is not binding. So it is not compulsory to follow what is being done under the English law. So for the laws which is made before this date, before 1956, 1951 and 1949 respectively, this law is binding in Malaysia. So whatever the older law have to be used in Malaysia, but the newer laws, you don't have to use it in Malaysia because it's no longer binding after the cut-off date. So the Malaysian court is not required to apply English common law as a whole. Yes, you can refer to English common law, but it is only applicable with two conditions. So you can only use English law in Malaysia in two situations. The first one, it is only applied in the absence of local statutes covering the same matter. So if there is no law regarding that thing in Malaysia, you can refer to English law. But if there is anything under the Malaysian law which talks about the subject matter that you are talking about, you cannot use the English law anymore. So there must be a lacuna in the law. Lacuna is like a hole. There must be some kind of absence of local statutes. There is no local statute, can refer to English. But if there is a local statute already made by our parliament, you can no longer use the English law. And then the second one, you can only use English law if there are local circumstances. So if the environment is the same, the society is the same, the law is applicable to the local circumstances, the law is suitable to be used in Malaysia, you can use them. But if the law is not suitable to be used in Malaysia, you can no longer use that law. So we have English law as a reference for as one of the sources of law in Malaysia. But as of now, because we already have quite an extensive legislations in Malaysia, we no longer use English law that much. Only the older laws for which give maybe some kind of uh, principles which are very what you call landmark principles, that one we still use. But all the newer laws, usually we use our own law right now. Okay, and then other than English law, we have another one, another sources of law in Malaysia, which is customs. So customs is what we call adat. In Malay, it is called adat. In English, it's called custom. So custom is what we call what is local practices. So in Malaysia, we have a number of customary laws. For example, we do have adat pepatih and adat temenggung, and Chinese also have their own customary laws, and we also have native customary laws which are applicable to the natives in Sabah and Sarawak. However, as I mentioned during our morning class, except for the native customary laws applicable in Sabah and Sarawak, customs are no longer an important source of law. So before this, in Malaysia, we do have what we call Mahkamah Penghulu court. But the Penghulu court does not exist anymore. It is already being repealed under the law. So now the only court which is customs is Mahkamah Adat, which recognize the native customary laws which are applicable in Sabah and Sarawak. Okay, so however, in certain areas such as marriage, divorce, and inheritance, court may look at the customary law of the relevant group of local inhabitants. So in Sabah and Sarawak, their customary laws is binding. So if they have any law regarding how to acquire land, how to inherit land, that kind of laws is to that community. So you have to follow their customs in order to acquire or to inherit any laws if you are part of the community. Okay, so that's all the what we call sources of law in Malaysia. Sharia law is, as I mentioned before, is only applicable to Muslims, and is only for personal law. Personal law, which is involving marriage, divorce, guardianship, legitimacy, and inheritance. So that's all the sources of law in Malaysia. You have any question before we continue with court system in Malaysia?
Yes, Miss. Just one question.
Mm-hmm.
It's also said that Malaysian law is quite similar to the English law that is in Britain. Does that mean that we can also
Sorry,
that we learned in Malaysia in Britain?
Sorry?
Yeah. Sorry, I'll just make it brief.
Okay.
Since Malaysia was considered a Commonwealth country, does that mean that the law that we learned in Malaysia, we can also practice it in the UK?
The older law, yes, but once we get our independence, Malaysia starts to make their own law. So currently, our laws are not very similar to English law, but maksudnya in deciding cases, or sometimes for example, we have a penal code in Malaysia. We have a law which governs criminal law in Malaysia, and our penal code is very similar to India penal code. So sometimes we do refer to Indian cases in order to interpret our own laws in Malaysia. Similarly, for English law, if the law is similar to what we have in Malaysia, we can refer to that case in order to help us interpret our laws in Malaysia. But as I said before, it is only persuasive. Persuasive meaning that you can refer to them, but you don't have to follow them. It is only persuasive. You can refer to them, but you can choose whether to follow them, or if you have your own opinion on, if our courts have their own opinion on the matter, maybe the court feels that whatever is applied in England is not suitable to be applied in Malaysia, the court can depart from English law because it is not binding. Does that answer your question?
Yes, Miss. Thank you very much.
Okay. Any other question? No question. Okay, so yeah, if you don't have any question, we will continue with the court system in Malaysia. So in Malaysia, we have five different types of court, five different levels of court, and the courts are organized in hierarchical order. So it have its own ranks in terms of power. So the lowest court have the least power. So the lowest court have not much power, and the highest court have the most power. So it is organized in hierarchical order, and cases starts in different courts depending on the nature of the claim and their monetary values. So there are certain cases that must be heard for the first time in high court. There are certain cases that can be heard for the first time in magistrate court. So it depends. Each court have their own power, and as I said, the lowest court have the least power, so they don't have much power, and the highest court have a lot of power. So the highest court in Malaysia is federal court, and federal court has the most power in Malaysia. Okay, so these are the level of courts in Malaysia. The lowest one is magistrate court, and we also have court for children, which is mahkamah kanak-kanak, and this court of children is on the same level with magistrate court. So cases involving children are usually heard in the magistrate court. I mean, it is usually heard by the magistrate because the court for children, mahkamah kanak-kanak, is on the same level as magistrate's court. And then up one level, we also have sessions court, mahkamah session. And then we also have high court. In Malaysia, we have two different types of high court. We have a high court in Malaya, and we also have high court in Sabah and Sarawak. So the difference between these two high courts is in Malaysia, we do have lawyers who can practice, but the lawyers can only practice either in high court in Malaya, or if they also want to practice in the high court in Sabah and Sarawak, they have to undergo some kind of internship. We call it chambering in Sabah and Sarawak. So we have two different types of high court. So if you, I'm not sure if you have heard about, if you want to be a lawyer, you have to undergo this period of chambering. You must be a pupil in chamber. Have you heard of pupil in chamber or chambering?
Miss, is it the bar exam?
In Malaysia, we don't have a bar exam, but you do have to undergo some kind of training. Some kind of training before you can become a lawyer. That is what we call pupil in chamber.
Oh, okay. Thank you, Miss.
Okay, so as a pupil in chamber, if you are doing your chambering in High Court in Malaya, you can only be a lawyer in Malaysia, in Peninsula Malaysia. So if you also want to be a lawyer in you have to undergo another pupil in chamber period in Sabah and Sarawak. And at the same time, if you are a pupil in chamber in Sabah and Sarawak, and you want to practice in Peninsula Malaysia also, you have to undergo the you have to undergo period in Malaya also. The High Court doesn't make much difference for ordinary people. For ordinary people, it doesn't make much difference, but it only make difference for people who is inside the legal profession, because there are different types of High Court. Because in Malaysia we have three highest judges in Malaysia. The highest one is what we call Chief Justice, Ketua Hakim Negara. And other than Ketua Hakim Negara, we also have Ketua Hakim Malaya and Ketua Hakim Sabah and Sarawak. So that's why we have this difference in High Court in Malaya, High Court in Sabah and Sarawak. For ordinary people, it doesn't have much difference. It's just that if your case your issue happens in Sabah, you have to go to High Court in Sabah. If your case happen in Sarawak, you have to go to High Court in Sarawak. It just make a bit of difference for people in the legal profession. But it just just for information, you need to know that in Malaysia we have two types of High Court. High Court in Malaya and High Court in Sabah and Sarawak. Okay, so other than High Court in Malaya and High Court in Sabah and Sarawak, we also have what we call Court of Appeal, Mahkamah Rayuan. So Court of Appeal is appellate court. So for Court of Appeal, they don't have any original jurisdiction. They don't hear case for the first time. They only hear appeal cases. And then the highest court in Malaysia is what we call Federal Court, Mahkamah Persekutuan. So the Federal Court, they have appellate power. They can hear appeals, and at the same time, they also have some kind of original matters that can be brought directly to the Federal Court. So we separate the Magistrate Court and Sessions Court and High Court, Court of Appeal and Federal Court into two different categories. Two different categories, which are the Magistrate Court and the Sessions Court is what we call subordinate courts, or in Malay we call it Mahkamah Rendah. On the other hand, the High Court, the Court of Appeal and the Federal Court is what we call Superior Court, Mahkamah Tinggi. So the difference between Sessions Court and Magistrate Court and the Superior Courts is when we talk about judicial decisions before this, we only use the decisions from High Court and above. High Court, Court of Appeal and Federal Court. We don't use decisions made by the Sessions Court or the Magistrate Court as a judicial as a precedent, as a judicial decisions, as a sources of law. So that's the difference between the two types of law. And then we also have one court which is called the Special Court, Mahkamah Khas. This Khas is only for state rulers and the Yang di-Pertuan Agong. Is there any difference? For Federal Court, I'll inform you. Actually, I do have a number of slides describing the power for each court. And we'll talk about that when we talk about the courts. There is a difference between the cases that the courts are taking. We'll discuss it in the following slides. Okay, so let me talk about Special Court for a bit. So the Special Court is a court that is used to adjudicate case which involves state rulers and the Yang di-Pertuan Agong. So if the Yang di-Pertuan Agong or the state rulers, any sultans, any raja commit any crime or commit any wrong in their personal capacity, meaning they commit the wrong not as a YDPA, not as a state ruler, but decisions but privately. So they made their own mistakes, or if they commit any crime, they will be their case will be heard in the Special Court. So this Special Court is only for Yang di-Pertuan Agong and state rulers, and it is only for the cases which is under their personal capacity, not as a state ruler, not as a YDPA, but their own personal problem. So for a sultan kill somebody, or maybe if a sultan injured somebody, his case will be heard in the Special Court. Okay, so these are the types of courts that we have in Malaysia, and we look at each of the court one by one to know what their power and what kind of case that they can decide. Okay, and after I explain about the courts, if you still don't understand about the powers of the court, you can ask them. Okay, so in Malaysia we have two different acts which talks about the jurisdiction of the different courts in Malaysia. The first one is the Subordinate Courts Act. Oh, I forgot to add the word act. The Subordinate Courts Act 1948 laid down the jurisdiction of the two subordinate mentioned just now, the two subordinate courts, the two Mahkamah Rendah is the Magistrate Court and the Sessions Court. So to know what are the powers of the Magistrate Court, what are the powers of the Sessions Court, what kind of case they can hear, what kind of decisions they can make, you can refer to the Subordinate Courts Act 1948. On the other hand, for the three superior courts in Malaysia, for the High Court, Court of Appeals and the Federal Court, their powers and their jurisdiction is laid down in the Courts of Judicature Act 1964. So you can refer to the Courts of Judicature Act 1964 if you want to know what are the what type of case that can be heard by the High Court, what type of case can be heard by the Court of Appeal and what type of case can be heard by the Federal Court. Okay, so we look at each court one by one. Okay, so we start with the court with the least power. Mahkamah yang ada kuasa paling sedikit. It is the magistrate court. So in Malaysia, we have two types of magistrate court. The first one is what we call first class magistrate court. And the second one is what we call second class magistrate court. So when we talk about criminal matters, if the case involves a crime, the magistrate court can only hear cases which is punishable with a maximum terms of 10 years only, maximum terms of imprisonment, sorry. So for criminal matters, when we talk about a crime, the magistrate court can only hear cases if the offence is punishable with a maximum term of imprisonment of 10 years. So when you look at the act, if the act, the maximum punishment is 10 years imprisonment, or the crime is only punishable with fine, denda sahaja, that case can be heard by the magistrate court. That is for criminal. So for criminal matters, they can only pass the punishment of imprisonment maximum 5 years. So the magistrate court, they can hear case up to 10 years, but they can only sentence up to 5 years of imprisonment. They can only sentence a fine up to 10,000 and maximum of 12 strokes of whipping. So this is the only type of punishment that can be given by a magistrate court. So that is for criminal, not really matter for your business law. But for your for business law, the one that matters is the monetary jurisdiction for civil matter. Civil matter is, as I mentioned before, it refers to cases where you can sue and get some kind of damages, some kind of ganti rugi. So in Malaysia, if the subject matter is less than 10,000 ringgit, for example, to someone because they fail to, for example, you are a businessman and you have an agreement with your supplier, and then your supplier fail to forward the products that you want, and you want to sue them. So if the damages that you have incurred, kerugian yang you alami tu less than 10,000, the case will be heard by the second class magistrate court. But if the subject matter refers to how much you want to claim. So how much you want to claim is, the claim is less than 10 class magistrate court. But if it is less than 100,000, it will be heard in the first class magistrate court. Defamation, right? Defamation. Shame suit under law is called defamation. And defamation, for defamation, I think it depends on how much are you suing for. For example, if you are suing for 75,000 ringgit, so you said that someone has defamed you, someone has said something that affect your reputation, and you want to claim for defamation. Defamation is saman malu. If the amount that you claim is less than 100,000, the case will be heard in magistrate court. But if you claim more than 100,000, maybe you claim defamation suit up to 1 million, for example. If it is 1 million, the case will be heard in a different court. Depends on how much you are claiming for. Okay, So it depends on, like I said, monetary jurisdiction, it depends on how much you are claiming for. So if you are claiming for 10,000, it will be heard in second class magistrate court. If you are claiming for less than 100,000, it will be heard in the first class magistrate court. This is cases that can be heard by the magistrate court. And then if your claim is less than 5,000, for example, maybe you had give some money to your friends because your friends is in hard situation. Your friends ask to borrow some money from you, so you lend them some money which is less than 5,000. For example, maybe you lend your friend money up to 3,000 ringgit, and then your friend refused to pay back your money. So what can you do is you can go for small claims procedure. So for small claims procedure, you can go directly to the court by filing a form which is called Form 164, and you can file the form, and then your case will be heard by the magistrate court. So if your claim is a small amount, less than 5,000, you can file it yourself. You don't have to find a lawyer, and the case will be heard by the magistrate. So you can claim for your money that your friend had borrowed and refused to pay back. So this is one option for anyone who had lend money to other people and the borrower refused to pay back to you. But only one condition: to be safe, whenever you lend any money to your friends, whenever you let your friend borrow any money from you, make sure it is in black and white, because it will help you when you want to claim the money in the court. Okay, so that is the powers of the magistrate court. Any question about magistrate court?
Ma'am.
Yes.
Okay, I have my mom's friend. She lent her friend almost like 78,000 for start up a business, but he refused to pay back the money for past like 3 years. And she should be registered under magistrate court, right?
Yes, because it is less than 100,000.
But she didn't put any contract over there. So if like that means she won't get the money, is it?
Dia under the law, for a contract does not have to be in black and white, actually. But if the contract is in black and white, it's easier for you to claim. So, but even if you don't have any black and white, if there is any proof that the person is borrowing money from your mother's friend, and that person admit that he is borrowing that money, you can take action in the magistrate court.
Okay.
It's just that when there is no black and white, it's quite hard to prove. That's all.
Okay, ma'am. Got it.
Okay, any other question? Yes, WhatsApp chat is last I checked, WhatsApp chat is acceptable as an evidence. So just to be on the safe side, whenever you want to lend somebody money or borrow or let anybody borrow any money, any amount of money from you, just make sure it is in black and white. It doesn't matter if it is in WhatsApp chat or maybe from a form of email or letters that they sign. At least it is in black and white, so it is easier for you to claim. Okay. Okay, so you have any question on magistrate court? No other question. Okay. So if there is no other question, we will continue with sessions court, mahkamah session. Okay, so for sessions court, first we look about on criminal jurisdiction. So for criminal jurisdiction, the sessions court, mahkamah session, can hear all criminal cases except offences punishable with death. So if the case is not punishable with death, that case can be heard by the sessions court. So they also can impose any sentences allowed by the law except the sentence of death. So the criminal jurisdiction of the sessions court is quite huge. They can try all criminal cases except what is punishable by death. So murder they cannot hear, but causing death can be heard by the Sessions Court. And they also can impose any sentence except the sentence of death. That is for criminal. For Sessions Court, for civil claim. For civil claim, if the claim is more than 100,000, if the civil claim exceed 100,000, but it is less than 1 million. So if the amount that you are claiming is more than 100,000 ringgit but less than 1 million, your case must be filed at the Sessions Court. Okay, and at the same time, if the thing that you are claiming for is concerning motor vehicle accidents, maybe one day you are driving and someone hit your car, and you want to claim damages from the person who has hit your car and caused damage to your car. That case will be heard under the Sessions Court. It will be heard at the Sessions Court, no matter how much the claim is. So it doesn't matter even if your car is a Lamborghini, which maybe damages cost maybe around maybe millions, but because it is a motor vehicle accident, it involves some kind of accident, the case can be heard by the Sessions Court. And another one, if the case is regarding landlord and tenant, which means that maybe someone rent a house from you, and then your tenant refuse to pay your monthly rental. Like now, during this pandemic of COVID-19, a lot of tenants lost their job, so many people don't have money to pay for their rental. So if your tenant doesn't pay their rental and you want to take action against your tenant, you can go to the Sessions Court, because the Sessions Court have unlimited jurisdiction regarding cases involving a landlord and tenant. So it doesn't matter how much you are claiming. Maybe your house is a very expensive house, which costs 10,000 per month, or maybe you are renting a commercial space which costs 10,000 per month, and the case is more than 1 million. So the amount you claim are more than 1 million. The case can still be heard in the Sessions Court because it is a landlord and tenant case. Okay, so that is the type of cases that can be heard by the Sessions Court. These are the type, but there are some kind of civil case that cannot be heard by the Sessions Court. So if your claim is on these matters, on these subject matters, you cannot file your claim at the Sessions Court, no matter how much the amount you claim is. The case must be heard by the High Court. The first one is probate and administration of estate. So it doesn't matter how many property you have. It doesn't matter if your property is less than 1 million. The case still have to be heard at the High Court. Also, if you are a non-Muslim, if you are not a Muslim and you want to get your divorce case, must be heard by the High Court. The Sessions Court doesn't have any power to hear your divorce case. Similarly, child custody. When you are divorced, you want to fight for child custody, you want to fight for the custody of your child, the case must be heard in the High Court. You cannot file your case at the Sessions Court. And another also, if your case is involving bankruptcy. In Malaysia, if you owe money more than, if I'm not mistaken, more than 60,000 ringgit, the person who lend you the money, the debtor, can file for civil suit to claim that money. And if the court give judgment for that debtor, for the person who has lent you money, they give judgment for that person. That person can take action to execute the judgment to get back their money. And one of the way they can use to get their money is through bankruptcy proceeding. So what they can do is they can file a bankruptcy proceeding against you at the High Court, and they will get the court to adjudge you bankrupt. So once you are a bankrupt, you will be under the jurisdiction of Jabatan Insolvency Malaysia. So your account will be freeze and you will be forced to pay a certain kind of money to settle all your debts. So bankruptcy cases also has to be heard. Sessions Court doesn't have any power to hear any bankruptcy case. Similarly, winding up case also have to be heard by the. So that is the power of the Sessions Court. Any question about Sessions Court?
No, Miss.
Anyone? No question about Sessions Court. Okay. So if the amount that you claim is in normal situation or in specific situation, when you ask about more than 1 million. More than 1 million is the case is about motor vehicle accidents or about landlord and tenant, still Sessions Court. But in other matters, it will be heard by the High Court. Okay, so if there is no question, we'll continue with the next court, which is the High Court. So High Court for criminal matters, High Court can hear any criminal matters. Any criminal matters, any kind of punishment, any kind of offense can be heard by the High Court. So if a case, a criminal case is involving case which is punishable with death, for example, cases like trafficking, drug trafficking, or cases involving murder, or case involving armed robbery which caused murder, or case of rape which caused the death of the woman. All those cases will be heard by the High Court because those cases are punishable with death. Only High Court have the power to hear case which involves death penalty. Okay, that is for criminal matter. And the High Court also have jurisdiction, have the power to hear cases involving probate. So when someone died and they have a will, or if someone died without a will, intestate, their case 1 MDB. I think 1 MDB is heard in. Wait, 1 MDB is heard in which court? No, 1 MDB case, let me see. Yeah, 1 MDB case is heard by the High Court because the amount is more than 1 million. If you see the court of 1 MDB, the case is heard enough because the case involving the transfer of 42 million ringgit. So it is obviously more than 1,000. So it will be heard by the High Court. So if the amount of money is more than 1 million, it doesn't matter how much is it, billions, trillions, it will be heard by the High Court. It won't go to a court which is higher than the High Court because Court of Appeal, they don't have any original jurisdiction. Court of Appeal cannot hear any case for the first time, and Federal Court can only hear certain type of case for the first time. Okay, so for cases involving probate, someone died with a will, without a will, it will be heard by the High Court. Divorce case for non-Muslim is also heard by the High Court, and also bankruptcy case is also heard by the High Court. And for civil matter, except the case of accidents, motor vehicle accidents, or the case involving landlord and tenants, all other civil matters, if the claim exceeds 1 million, if you claim for more than 1 million ringgit, your case will be heard by the High Court. So how to know which High Court to go to? So this is the civil jurisdiction of High Court. The High Court has jurisdiction to try all civil proceedings within its local jurisdiction where the cause of action arose. The defendant resides or have place of business. The facts occurred at that place or the land is there. So for High Court, if the case, for example, the case of um, for example, a tort case. Someone has negligently caused, if you remember the what I said during the morning class, a waiter, for example, the waiter works at a restaurant in Shah Alam. A waiter works at a restaurant in Shah Alam, and the waiter while carrying their uh, tray, they spill some soups on a customer. So the customer wants to take action against the restaurant. So it falls under the first one. The cause of action arose at Shah Alam. So the case will be heard in Shah Alam High Court. The level of court depends of for civil case, yes. For civil case, the which court you have to go to depends on the amount of your claim and the type of your claim. Yes. Some type of case can be more than 1 million but still be heard in the sessions court, and some kind of case might be less than 1 million but it's still heard in the high court. It depends on the amount of claim and the type of case. Yes, that's correct. So in high court you have to see, for example, like I said, if the case of negligence in Shah Alam, the case will be heard in Shah Alam High Court. In Malaysia, each states usually only have one High Court, except Selangor, I think have more than one. I know that Selangor have Shah Alam High Court and Klang High Court. KL, you only have one High Court. Pahang, maybe you will have more than one. I'm not sure. Sabah and Sarawak also you only have one High Court. So it depends on where the case happens. So if the case happen in certain states, the case will be heard by the High Court in that place. Or for example, if the case involves people from more than one country. For example, you have a contract between a company which is based in US, and the company is based in US but they have a branch office in Kuala Lumpur. For example, the company is based in US but it have a branch office in Kuala Lumpur. You can use the second one. The defendant or one of the several defendants has his place of business in Kuala Lumpur. So the case can be heard by High Court of Kuala Lumpur. So if the case involve lands, for example, there are dispute on lands. The land is in Kelantan. So the case have to be heard in High Court of Kelantan. So that's how you determine which court to go to when you want to take any action. So it depends on where where the problem happened, where the defendant live, or if it involves land, where the land is. So that's how you determine which High Court to go to. Okay, so that is the jurisdiction of High Court. Oh, one more. High Court also have jurisdiction to hear criminal and civil appeals against the decisions of the subordinate courts. So in Malaysia, each case can be tried 3 times. So when you heard the case for the first time in magistrate court, for example, you heard the case for the first time in magistrate court, and you don't agree with the decisions of the judge, what you can do is you can appeal. You can case is heard for the first time in High Court. Is heard for the first time in Magistrate Court. If you want to appeal, which court do you have to go to? The case is heard for the first time in Magistrate Court. You don't agree with the decision of the court, so you want to appeal. Which court do you have to go to appeal your case?
Session court.
No, because Sessions Court doesn't have any appellate jurisdiction. You have to go to the High Court. Yes. So if the case starts from the magistrate court, the case will be heard at the High Court because Sessions Court doesn't have any jurisdiction to hear appeal case. So appeal case cannot be heard in the Sessions Court. So if the case starts at magistrate, it will be heard for the first time in the High Court. And then if you does not agree with the decision of the High Court, so for the first time you have appeal from magistrate to the High Court. Yes. If you are still does not agree with the decisions of the High Court, you can appeal again at the Court of Appeal. If you still does not agree with the decision of the Court of Appeal, can you do anything? If you still does not agree with the decisions of the Court of Appeal, you have appeal from magistrate, you have gone to High Court. High Court, you have gone to Court of Appeal. You still want to appeal. Can you do so? No. Yes, Azida is correct. You cannot appeal more than 2 times. You can only appeal first time, another time. Only 2 times only. So if the case starts at magistrate, it will the final the final venue for appeal is Court of Appeal. Similarly, if the case starts in Sessions Court, so it will be heard if the case is heard for the first time in the Sessions Court, and then you does not agree with the decisions made by the Sessions Court judge. So you can appeal for the first time, you can appeal to the High Court. At the High Court, if you still does not agree with the decisions of the High Court, you can appeal again at the Sessions Court. But if you still does not agree with the decisions of the Court of Appeal, you cannot do anything because you can only appeal 2 times only. Okay, so that is the power of the High Court. They can hear case for the first time. Case for the first time is what we call original jurisdiction. If you can hear the case for the first time, it is said that you have a original jurisdiction to hear the case. You have the power to hear appeal case. We call it you have an appellate jurisdiction. You have the power jurisdiction to hear appeal case. So High Court have power to hear appeal case. Okay. So any question about High Court? Okay. So if you don't have any questions about High Court, we continue with the next court, which is the Court of Appeal. So Court of Appeal, they do not have any original jurisdiction. They only have appellate jurisdiction. So it means that they cannot hear case for the first time. So they cannot hear any case for the first time. No case can start from the Court of Appeal. They can only hear appellate cases, appeal cases. So they hear civil and criminal appeal cases against the decisions of the High Court. So any case must be appealed to the High Court first, then it can be appealed to the Court of Appeal. So in the Court of Appeal, similarly in the Court of Appeal or in the Federal Court, they don't have only one judge. For the lower courts, for example, in the Magistrate Court or the Sessions Court or the High Court, you only have one judge. So only one judge will hear your case and make decisions. But when we go to the Court of Appeal and the Federal Court, the judge that sit in a Court of Appeal or in a Federal Court case, at least they must have 3 judges. At least 3, or if they want to have more than 3, it must be in what we call nombor ganjil. So it must be 3, if not 3, 5, not 5, 7. 7, 9. It must be even number, odd numbers. So the judges must be in odd numbers. That is for Court of Appeal and Federal Court. So Court of Appeal, I don't think you have any question because it's just simple. The last one, the highest court in Malaysia. So the Federal Court. What type of case can be heard by the Federal Court? So the Federal Court can only hear cases which is an appeal case from Court of Appeal, and the case, and usually they only hear cases which starts from the High Court. So the case usually is heard for the first time in High Court, and then if the people who are involved in the claim does not agree with the decisions of the High Court judge, they can appeal to the Court of Appeal. If they still doesn't agree with the decisions of the Court of Appeal, they can appeal again at the Federal Court. So Federal Court only hear cases which starts from the High Court for appeal cases. And Federal Court also have some what we call original jurisdiction. So they can hear some cases for the first time, but only in this matter. Only these two things can be heard for the first time in the Federal Court. First one, power to determine whether a law made by Parliament or the State Legislative Assembly or DUN is invalid in the beginning of this topic. The highest law in Malaysia is a federal constitution. So if you make any law which go against the federal constitution, or if you make a law or if you make a subsidiary legislation which go against the act, that case, if you want to challenge the law, the new against the federal constitution, or the new law is against the parent act, you have to go to the federal court. Only the federal court have the power to determine whether a law made by Parliament or DUN is invalid. So the only court that can decide whether the law is against the constitution or not is the federal court. So if you want to claim that a law is against the federal constitution, you have to go to the federal court. That is one. The other one is if there is any dispute between states. For example, kerajaan the state of Selangor and the state of Negeri Sembilan is fighting over something. So their fight will be heard by the federal constitution. It will be heard by the federal court. And if there is any dispute between the state government and the federal government, for example, Kerajaan Malaysia have any issue with the state of Terengganu, maybe over oil, because the federal government wants to claim oil which is in Terengganu. The power to determine that dispute is the federal court. So both the federal government and the state government have to go to federal court to settle their matter. So that is two original jurisdiction of federal court. Okay, so other courts in Malaysia, we also have Syariah Court and Native Court. So Native Court is for Sabah and Sarawak. And we also have Industrial Court. In Malaysia, we have Industrial Court. So if the case is involving employer and employee relationship, someone is terminated or someone is fired, or you work for your company but you are not paid OT. Yeah, I'm not sure if you have heard that case. Before, I think just a few days ago, some cleaner claim under the industrial court claim for OT because she is required to work more 1 hour extra every day, and the company refused to pay her OT. So she claimed at the industrial court and she get. The OT is not much, I think, just around 1,000 or 2,000 ringgit only. But she can go. So if your company refuse to pay you OT, which is you are entitled to, you can go to industrial court to get your money. If it involves employee, the venue is industrial court. And then if the case involve a ruler, YDPA yang di-Pertuan Agong, the case will be heard by the special court. So that is the courts that we have in Malaysia. Do you have any question about any of the courts that we have in Malaysia, or do you have any question on the jurisdiction of the courts in Malaysia?
Yes, Miss.
Yes.
Regarding that, the court that settles disputes among the states, can it be more than 2 states as well?
Yes, because the wording in the federal constitution states that determine any dispute between states. So maybe if the dispute is not only between Selangor and Kelantan, but it's also between Selangor, Kelantan, Terengganu and Perak, yes, the case will still be heard by the federal court.
Okay, Miss. Thank you.
Okay. Any other question? Okay, so if you don't have any question, we'll continue a little bit on the basic terminologies in law. So this, as I said before, it's just some of the basic terminologies in law. And even before this, I already tell you about some of the terminologies in law, like original jurisdiction, appellate jurisdiction, appeal. All those things are what we call something which is specific to law. So there are some basic terminologies in law. For example, when you heard, when you read a newspaper, or when you read a case, a court case, if it states something about the plaintiff brought an action against the defendant, or it states that the plaintiff brought a case against the defendant, the plaintiff sued for compensation, the plaintiff filed an action against the defendant, all of this means the same thing. So it means that the plaintiff is not satisfied with the defendant. Maybe the defendant had commit any wrong. It doesn't matter whether it is a tort wrong or it is a contract wrong. So the plaintiff will sue the defendant. So if a plaintiff wants to sue a defendant, if the plaintiff wants to take any action against the defendant, these are the terms that is going to be used. And it all means the same thing. The plaintiff wants to take action, wants to sue the defendant for something. He wants to get some kind of compensation. Okay, so this is one of the words that you will read so often if you read a court case. And then next, jurisdiction. Okay, how about case Ili Najwa? She is a Muslim but married to non-Muslim, and she married outside the nation. Married outside Malaysia, you have to register your marriage in Malaysia. If you are married outside Malaysia, you does not register your marriage in Malaysia, you cannot you are not you are not recognized as a married couple in Malaysia. It is similar to case when some people goes to Thailand to get married. If you go to Thailand to get married, when you come back to Malaysia, you have to file for pengesahan perkahwinan. So you must file to register your marriage in Malaysia. Register your marriage in Malaysia, you are not recognized as a married couple in Malaysia. If you are not recognized as a married couple in Malaysia, what is the problem? You cannot claim anything under the law because you are not a married couple in Malaysia. Overseas, we do have this case of what we call common law wife. For example, people who do not get married but they cohabit, they live together for so long, they have children, they have properties together. Overseas, you can claim that you are a common law wife. So even if you break up, you still can claim just like what a wife can claim from their husband. Yes. If you married outside Malaysia, you have to register your marriage in Malaysia. I'm not sure about compound. What do I know about compound is if you married without usually I'm not sure the non-Muslims are familiar with this, but Muslims, some of them, they get married to their second wife overseas in Thailand. So in Malaysia, we have this rule that if you want to for a second wife or third wife, you have to get permission from the court. So usually these people who get married in Thailand is compounded. They have to pay fine because they don't get the permission to get married. That's why they have to pay the compound. I think in normal situation, for example, if you and your husband study together in the UK and then you get married in UK, you can just go back to Malaysia and register your marriage. I don't think you need to pay any compound. Does that answer your question? I think the compound is for people who get married more than once for the second time without the permission of the court. Okay, for jurisdiction is power. Basically, jurisdiction is power. The court have the power to make legal decisions. It is within its jurisdiction. So for example, when we said that the Sessions Court have jurisdiction to hear all criminal cases except offences punishable with death. It means that the Sessions Court have the power. They have the power to hear all criminal case. So any criminal case except it is punishable with death, that case can be heard by the Sessions Court. So that is what we mean by jurisdiction. Jurisdiction basically mean their power lah, kuasa. So that is jurisdiction. And then we also have terms like original jurisdiction. Original jurisdiction is like I mentioned before, it is when you hear the case for the first time. So when you hear a case for the first time, what is the benefit of hearing the case for the first time is if you heard a case for the first time, you can call all the witnesses. Only the court with original jurisdiction can call witnesses. You can call witnesses, you can hear the testimony from all the witnesses, you can review all the evidence that the public prosecutor or the plaintiff have. So that power is only given to the court with original jurisdiction. So if you have original jurisdiction, you can hear all the you can see all the witness, you can observe how the witness act, how the witness react. You also can see all the evidence, you can ask questions to the witnesses. So that is the benefit of a court with original jurisdiction. So courts like Court of Appeal, which does not have any original jurisdiction, they don't have any rights to call any witness. They also don't have any rights to review evidence for a second time. So they only have to on whatever that had been reviewed by the High Court. So that is original jurisdiction. So basically original jurisdiction is when you heard the case for the first time. And then appellate jurisdiction. Appellate jurisdiction is the court which have the power to hear appeal case. So when a party is not satisfied with the decisions of the court, so the case is heard for the first time in High Court, and the party who lose in the High Court does not agree with the decision of the judge in the High Court. They believe that the judge has made some wrong decisions. So they want to appeal. The court that can hear the appeal is the court which have appellate jurisdiction. So like I mentioned before, Sessions Court does not have any appellate jurisdiction. So any case, any appeal case cannot be Sessions Court. Okay, so in Malaysia, the court that have appellate jurisdiction, we only have 3 courts which have the appellate jurisdiction, which Court of Appeal and Federal Court. Only these 3 courts have appellate jurisdiction. And then there's civil case and criminal case. I'm sure you are familiar with the difference between civil and criminal. So civil case is when it involves 2 parties, and it is not it does not involve the it is not a crime. So when it is not a crime, it is a civil case. So when we talk about civil case is usually between a plaintiff and a defendant. So the plaintiff is someone who has suffered damage, and the defendant is someone that you said had committed the wrong. So that is civil case. Civil case is usually between a plaintiff and a defendant. So civil case, there are various areas of law which have civil cases: contracts, land law, torts, commercial, sales of goods, everything. It is under. So when you claim for under a civil case, you file for a civil lawsuit, you will usually get monetary compensation in the form of money. There are some kind of other damages that you can get, but usually you will get money for civil case. On the other hand, criminal case is when someone commit a crime. So when you commit a crime, the punishment for a crime is, for example, imprisonment. So if some of the offense is punishable with imprisonment, you can be imprisoned. You can be put in jail if you commit the wrong, or you can be sentenced to death if you commit the wrong, or you can be fined. You boleh didenda, or you can be whipped. You boleh disebat di atas kesalahan tu. That is a criminal case. So criminal case is against between a public prosecutor and the accused. So that's the main difference between civil case and criminal case. So for civil case, you will call the parties plaintiff and defendant. In criminal case, you will call the parties public prosecutor and the accused. pendakwa raya and tertuduh. So that is for criminal case. And then courts, we have two categories, as I already mentioned before. Subordinate courts consist of magistrate and sessions. They only have certain types of jurisdiction and they can only hear certain types of case. Whereas the superior court, we have a high court, court of appeal and federal court. They have more power compared to subordinate court. They can hear more cases and they can hear cases which involve a lot of money. So if the case is more than 1 million, it can be heard by the superior court. And appeal cases can also be heard by the superior court. So plaintiff and defendant I already mentioned before. So that's some of the basic terminologies of law that comes into my mind when I prepared the slides. Have you heard any other terminologies of law that you are interested to know? What does it mean? Maybe you come across it in the newspaper, or maybe you watch some videos about anyone talking about law, and you are curious about what does some basic terminologies of law means. Anyone have any question regarding the terminologies?
So far, none yet, Miss.
So others? Okay, so if you don't have any question, I will give you a break first, and after the break, we will do some activities. So I will give some questions, and I want to. Option. Okay. So after your break, we will do some kind of activities. I will give some questions for you to answer. And then after you answer the question, we will discuss about your answer. So I'll maybe break you up into breakout rooms. I'm not sure how the breakout rooms works because I have not explored it yet. But we'll try after the break. So I'll give you a break. Maybe until 4:30. So 4:30 you come back to class. Is that okay?
Okay, Miss.
Okay. Okay. Hello guys.
Hi, ma'am.
Yang regarding the one where which you said that if you before this I already stated that if you are married overseas you need to come back to Malaysia and register your marriage, right? I just checked the law on that. Within 6 months after you get married overseas, you have to register your marriage in Malaysia. If not, you will be fined. There is a compound. I think 100 ringgit per 1 year of late registration. Okay, and then before we start with our activity, I already shared the activity questions inside the WhatsApp group. Usually, how do you take your attendance? Usually, how attendance is taken? In your other classes, how do you take your attendance?
You can download the attendance.
Also, it is usually taken manually, like using during the class. Is it right? Is it like that?
Madam,
Mm-hmm.
usually what other lecturers would do is that they would open their like lecturers have their own attendance form that it's in the unique. I am not sure where is it, but usually lecturer would just take the attendance just by clicking at that one form.
Oh,
Yeah,
I need to ask Puan Nadia how did she do it.
yeah, I
For
think that.
because I already found your attendance in your UNIEC website, but I don't know if you can click it by yourself. So for today's class, can we just take our attendance manually? So I just call out your name, and if you are here, just say yes, you are here. Is it possible for today's class? And then for next week I'll ask Puan Nadia how to take the
Madam,
attendance.
Sure, Miss.
Okay, no problem, eh?
Madam got another way also, madam.
How?
You can see from you got participant column there. When you they got option, you can download attendance from there.
Download attendance from the participants.
Yeah.
Oh, how? Sorry, because it's my first time using Microsoft Teams. I don't know how to do it. More actions. Download attendance list. Yeah. Good idea. Bagus. Hopefully you all use your own name, yeah? MC2001, what is your name?
My name is Marvin, madam.
No, your name, I can see it from your holder. This MC2001109290. Who are you? What is your name? Attendance meeting. So most of you are using your origin. Yeah, this one is easier. It's most of you are using your your full name, so there is no problem. Only one student. I don't know what is your name. Mm, There's just one student. I don't know what's your name because you don't use your own name inside the Microsoft team. It's okay. So most of you, I'll just take your attendance based on what I already downloaded. And okay, now we'll try to break up you into a few rooms. 6 rooms. How many questions are there? Okay, I already put you inside your breakout rooms. Only 2 students cannot be put in rooms. Oh. Okay, so all rooms are open. Okay, so you are already put in your rooms. Can everyone hear my voice? Inside the room, can you hear my voice?
Madam, there are still, Miss, there are still a lot of people that haven't entered. There's only 13 people in this class right now.
Oh, so okay. So is everybody inside the breakout room? I don't know how to use this breakout room actually.
Miss?
Yes.
I'm quite confused of what's happening right now.
How? Yeah, I put you inside groups so that we can discuss, but I don't know what happened. If I close this room, wait. How? Actually, want you guys to discuss in groups. I don't know how.
Miss, I think the system crashed or something because we're all like back in the main page like that. So I guess it crashed. I'm not sure because this break room session only happened like once only. That's the reason.
Oh. I want to try something new, but it's hard. I just close. If I close the breakout rooms, what happen? Everyone will be. What will happen if I close the breakout rooms?
I assume everyone should return back to the main channel here.
Because people keep being people being kicked from the class because many are waiting in the lobby. Wait, if I close the rooms. Wait,
Madam, can we create our can we find our own group members?
wait.
Okay.
I want to try something new, but I don't think it's working. I just closed the breakout rooms. Oh,
The exit dari grup.
sekejap. Okay. So now is everybody back in the main page?
Yes,
Yes,
miss.
miss.
Okay. So because I don't know how to use the breakout room, so maybe you just can you guys can just put yourself into own groups, because I want to do something like I want you to question I want us to discuss the answer. That's why I don't want to use Kahoot. I want you to do discussion, and then we'll discuss the answer together. So maybe if I put you in your groups, and then I ask like group 1 answer question 1, something like that. That's what I plan to do, but I don't know what's happening. So I think it's better that you just put yourself in groups, and you answer the questions that are already given inside the WhatsApp group, and then can we discuss the answer like maybe in 30 minutes time? Is that enough? 30 minutes to answer all the questions? Hmm? Cannot hear you.
What about this? Is it okay?
Okay, madam.
I think that's how we can do it for this class. So you just find your friends and discuss. Group members, that's why I actually want to use the breakout room, but it doesn't work. So for today, you can discuss with your friends, or if you want to do it by yourself, you can also do it by yourself. And then in 30 minutes time, we'll start to discuss, and I'll just pick any names to answer the question. So everyone needs to know the answer. You can do it by yourself, you can do it in groups, no problem. Is that okay for everyone?
Okay, Miss.
Okay, so around 5:30.
Okay, ma'am. Okay, ma'am.
So around 5:30, we'll start to discuss the questions. Okay. Our discussion now.
Miss.
Yes.
I actually just now during the break I wanted to watch back the recording of our mass lecture.
Mm-hmm.
It's in the other channel, but I'm unable to watch it, lah, Miss, because it's.
So you try to rewatch it using the UNIC website ke?
No, I press here in this Teams.
Oh.
It's
Oh,
actually there.
because
I asked my friend too. She said the same thing. I can't open. We can't open. Yeah.
because this morning after I finished the lecture, I did download it, but I don't know if that affects how other people can see it. But I actually plan to upload it again inside the YouTube so that everyone can access it. So, but I'm not sure why you cannot see, why you cannot watch the video anymore.
Oh,
Because
okay.
this morning I can watch it. I watch it and I already downloaded it. So I plan to upload it on YouTube. So I'll share the link to the YouTube.
Mm-hmm. Okay, can Miss. And Miss, one more thing, in the unit virtual under business law too, there are like multiple files like coursework, law of tort, law of contract apa semua. Bawah like bawah sekali tu there's like one file for recorded online classes.
I'm currently exploring that.
Oh, okay, sure.
Okay.
Miss. Anything you can just
So
update at the WhatsApp group.
yeah.
All right, thank you.
Okay, thank you.
Madam, my group have been finished, madam.
Okay, so other groups are you all finished or you haven't finished yet? Can we start the discussion now?
Yeah, sure, ma'am.
Okay. So I'll just pick any name Nurul Ain binti Zami ada? Nurul Ain binti Zami, are you here? Nurul Ain, are you here? Okay. Or do anyone wants to try to answer question 1?
Madam, can I try?
Okay.
Okay, wait a minute, madam. The law is okay, I must read the question also, right, madam?
Yeah, you read the question.
Okay, the Donak drinking a bottle of ginger beer in a cafe. That snail was in the bottle. She fell ill and she sued the ginger beer manufacturer, Mr. Stevenson. Court held, the, court held that Mr. Stevenson owed a duty of care to her, which was breached because it was reasonably foresee that failure to ensure the product safety would lead to harm to customers. This later became a law known as a tort of negligence.
Okay.
So I have tried of answering, madam. The principle there then it was established the principle of duty of care. So the duty of care means according to this case, a individual or a individual act that could be what not possibly possibly harm others. So because of that, this duty of care have been inverted.
Okay. But the question is which source of law is applicable? So for this type of question, what source of law you think is applicable for this case, for this situation? We learn about
Source
5 sources of law: federal constitution, written law, unwritten law. Which sources of law you think is applicable for this situation?
I think it's unwritten law, madam.
Unwritten law, which one?
In unwritten law, I think the federal. That's the English law. I think.
Um, yes, English law, but it's actually also under the sources of law, judicial decisions. You
Oh,
remember? Yeah. I did mention before, judicial decisions is for something which is the first time situation. So, like in this case, during that time, this is a very old case. We will learn about this case when we learn about tort next week. So, when this case happened, when Mrs. Donahue drink that bottle of ginger beer, where there is a snail inside the bottle, during that time there is no law in which someone who fell ill after drinking something which is rotten, there is no law that states that that person can claim, because during that time, if you want to claim, you have to have a contract. So in this situation, Mrs. Donahue does not have any contract with Miss who buy the ginger beer is not Miss Donahue. The one who buy the ginger beer from Mr. Stevenson is the owner of the cafe. So there is no relationship of contract between Mr. Stevenson and Mrs. Donahue. That's why during that time, this is a new thing, something that never happened. So that's why they create a new law. So law of negligence is actually a new law which is created. Okay. So it is a judicial decisions that becomes a law later on. So the
oh,
for the first,
okay.
yeah. So the
This
first
judicial
question.
decisions. It's first time happening as a before. It's not have not happened like that. Okay, madam.
So before that, no one have ever, no customer have ever sued the manufacturer for selling them apa
The ginger
products
beer.
that is not good. Yeah. So this is the first time. So this one falls under the category of judicial decisions. It also falls under the category of English law because this is very old case which happens before the cut-off date. So you can use both law, both sources of law to answer that
Okay,
question.
madam.
Yeah.
Thank you,
Okay.
madam.
Okay. So that is for question 1. For question 2, anyone else wants to try to answer question 2?
Ma'am,
Yes.
I just try, ma'am.
Mm-hmm.
Okay, for the second, me and my group choose the parliament that who should take the decision. I mean, yeah, made the decision.
Mm-hmm.
Why? Because what do we call whenever when it comes to like citizen security, it falls under federal law list.
Mm-hmm.
Okay, and then so when it comes to federal law, all the parliaments always make the decisions.
Okay. So that is correct. The answer is correct. So the question is whether the law should be made by the parliament or by the Dewan Undangan Negeri. So in this case, yes, the law should be made by the parliament because it is if you read the question if you read the question carefully, it said that they wants to make a law which made it compulsory for all cars, lorries, bus to install dashboard cameras. So when something is compulsory, something is diwajibkan, if you do not do it, it is a crime. It is a crime. It is an offense. So it is a crime. So when it comes to something that is a crime, when you did not do it, it falls under criminal law. So criminal law, yes, it is under the it is under the power of the parliament to make laws regarding criminal law in Malaysia. So your group's answer is correct. So maybe you can add on what I said inside your answer. Okay, so any other group have any other answer for question 2? Maybe someone have a different
Uh,
idea?
Madam,
Yeah.
for our group, we just choose parliament because
Uh-huh.
instead of Dewan Undangan Negeri, which is the name itself considered just to be implemented in the state,
Yeah.
and that's why we chose the parliament. We
Oh.
want to implement the whole nation.
Oh yes, that is also correct because when you create it under an act, it will be applicable throughout Malaysia. So, but if you made it just under Dewan Undangan Negeri, it can only be applicable in that states only. Okay, so that is question 2. Question 3. Any other group want to try to answer question 3? Question 3. Anyone wants to try?
Actually, we be a bit confused with the question because it
Ah.
says Melaka has declared 15 April as the public holiday. Is it
Uh-huh.
being applied to throughout the whole Malaysia or just in the Melaka?
Oh,
Yeah,
the
we got a
question
bit
actually
confused.
means that the public holiday is declared in Malacca.
Oh, okay.
Uh-huh. So how your group answer the question?
So is it only Melaka, miss?
Yes.
Okay, if only Melaka,
Mhm.
I will say it's legal because it's
Yes.
only for it's a state order, right? State law.
Mhm. Yes. So anyone else have any other answer?
It should be legal because Melaka have this historic city which is
Uh-huh.
being known into the World Heritage. So I think
Okay.
there should be no problem implementing the public holiday.
Okay. So any other group have any
Miss
other
over
answer?
here.
Yes.
Yeah.
Uh-huh.
My answer is that I did a bit of research of the bit of something. It's legal because under Section 8 Holiday
Mm-hmm.
Act 1981.
Mm-hmm.
Miss, when there is an act of something, I don't know, act of holiday, act of religion, ke apa-apa, like any types of act, is that act like considered under the federal constitution or like?
Yeah, when you when you enact an act, when you create an act, that act must be consistent with the federal constitution. So if the federal constitution have no problem with you creating that act, you can create that act. So that act, what is the act name? State Holidays Act.
Section 8 Holiday Act 1981.
Oh, I never heard of that act before.
Yeah, I never heard of that too. But like, yeah, I did a bit of research. So if like it's legal and it's for Malacca,
Mm-hmm.
means that it's also as state law, but it's at the same time it's federal constitution. Miss, I'm a bit confused of the answer for this.
Okay, actually the answer is quite simple, because if you see inside the ninth schedule of the Federal Constitution, it did state that state holiday is under the jurisdiction of the state. So any state can declare any public holiday for their own states. So if you want to start answering the question, you can start with what is inside the Federal Constitution. So inside the Federal Constitution, under the ninth schedule, list 2, each state does have their own power to declare any day to be a public holiday for their own state. Yes, and it is also supported by the act that you find, the Holidays Act 1981. Is it Malaysia? Why do I think it's not Malaysia? I think it's New Zealand lah.
Oh wait, what? That act means?
Is it Malaysia? Is it in Malaysia? Because when I Google it, it stated that New Zealand Holidays Act 1981.
No, Miss, Malaysia Holiday Act 1951.
Oh, okay. Yeah, I must have typo, Miss. Sorry.
But because the Federal Constitution does state that each state has public holiday, so when you have an act stating that you can declare any day to be a public holiday for your state, that so it is no problem, because the both acts and the Federal Constitution is saying the same thing. So Federal Constitution said all states you can create whatever public holiday you want to create, and the act also said the same thing. The state can create a public holiday for their own state. So both laws are saying the same thing. So there is no problem using both laws to answer the question. So first you state about the Federal Constitution, and then because you have done a further research, you can also talk about the Holidays Act. Wait, aku nak baca apa dia dapat Holidays Act. The minister may put any day to be a public holiday. So correct. So the answer is correct. You can use both lah. You can use the Federal Constitution, the second list of the ninth schedule, and you also can use the act now in order to support your answer.
Okay, Miss. Miss, one more thing. The person who approves this holidays or anything, it's the Menteri Besar of the state. Is it right, Miss?
Yes. If it is for the state, it is the Menteri Besar. Because Menteri Besar is considered the exco, the executive of the state. Okay.
Understood, Miss. Thank you.
Okay. So that is for question 3. So Melaka the Melaka can declare 15 April to be a public holiday for Melaka only. They cannot declare a public holiday for the whole country, because it is a state holiday. But if the public holiday is declared by the federal government, for example, few years back, we don't have a public holiday for Hari Malaysia. You do know that we have Hari Malaysia on 16 September 1963. Before this, 16 September 1963 is not a public holiday, but the federal government has declared that 16 September 1963 is a public holiday. So since then, because the announcement is made by the federal government, it applies to the whole Malaysia. But like in the question, because it is it is declared by the Melaka and is declared by Melaka, it is only applicable for the state of Melaka only. So that's the difference. If it is announced by the government of Malaysia, it will be applicable throughout Malaysia. But if it is decided by the state, it is only applicable for that state only. Okay. Is it a state holiday? Any question about state holiday? No question about state holidays. To the next question. Question 4. Okay, anyone wants to try to answer question 4?
Miss.
Ah.
Oh my God. Sorry, Miss. Is it okay if I try?
Yes.
So Zuleika and Yusuf are getting a divorce. Discuss which laws to be used when dealing with. So the first one, the dissolution of their marriage, should be considered under Sharia law because it is very clear and stated that both of them are Malays, and and only the Sharia law can dissolve a marriage between. And oh, sorry, where was I? Yeah, only the Sharia law can dissolve and unite a marriage if they are both Malays. The custody of their two children should be also in the decision of the Sharia law because, well, in order to who to split, which parent will get more custody of their two children, the matrimonial property or their asset can
Putus.
a judicial decision or the Sharia law.
Okay, so the answer is correct because
Nice.
both okay. The answer is correct, but not because they are Malays. The answer is correct because they are both Muslims.
Okay, I see.
Okay.
All right, so okay. Thank
So
you, Miss.
yeah. So as I stated before, Sharia law is applicable only for Muslims, and it is only for personal laws. So if Muslims want to get married, and Muslims want to dissolve their marriage, they want to get divorced, or they want to fight for the custody of their children, or they want to distribute their matrimonial property. Matrimonial property in Malay is what we call harta sepencarian. If they want to divide all these things after they have gotten divorced, all must be heard in the Sharia because both are Muslims. But if these issues happen between Cheng and Susan, or maybe between Revita and Sanjadev, because both are non-Muslims, case will be heard by the civil court. If it is the issue of this divorce or custody or matrimonial property of non-Muslims, which court have the power to hear the case? If this happens between non-Muslims, which court have the power to hear the case?
High court maybe?
Federal
Yes.
court, Miss?
Oh no, not federal court.
High court.
High court, high court. Federal court
okay.
doesn't hear case like this. So yes, if the same thing happens between a non-Muslim, all these things will be heard in the High Court of Malaysia, because only High Court have power to decide everything relating to divorce and custody. Okay, so that is question 4. Okay, so we go to the next part, which is court system in Malaysia. For question 1, who wants to try?
Miss, if it's okay, I would like to try to.
Mm-hmm.
Should I read the whole question, Miss?
Yes, please.
Okay. Kasut Cantik Sendirian Berhad is a tenant who had rent a shop house owned by Mr. Lim Kiat Singh, quite a familiar name. The rental agreement had stated that rental is renewed yearly and will end on March 2021. Due to due to the pandemic, the shop house is not profitable, and the company planned to terminate the rental agreement 6 months after it is signed in September 2020. Mr. Lim refused to accept termination and claimed that Kasut Cantik Sendirian Berhad had breached their rental agreement. He wants to take legal action against Kasut Cantik Sendirian Berhad. Which court has the jurisdiction to hear the case filed by Mr. Lim, and why? Miss, my answer would be that it would be the session court, which has the jurisdiction to hear the case filed by Mr. Lim. This is because the session court hears any civil matter involving like motor accidents, dispute between landlords and tenants, and some distress action. So it would be session court.
Mm-hmm. But if the damage is more than 1 million, can it still be heard by the sessions court?
No, madam, because session court, their dispute damages cannot be more than 1 million, if I'm not mistaken.
Okay, so your answer is for A. The court that can hear the matter is sessions court. But
yes.
For second one, for B?
For B, yeah, if Mr. Lim plan to sue for damages amounting to 1.2 million, can he file the claim at the High Court? The answer is yes, he can file. He can go to the High Court because the sue amount exceeds 1 million, so the Session Court doesn't have the jurisdiction to handle this. So this allows the High Court to have jurisdiction over Mr. Lim as the damage exceeds 1 million.
Okay, thank you. Abdul Hadi, you did not agree. Why?
From my point of view, from my understanding, is that all of cases that regarding landlord within because it has unlimited jurisdiction, right? So that's my understanding, that even though the amount is exceed 1 million, maybe still the case will be held in the session court. That's my
So your answer for A is?
That's session court.
Sessions Court. B?
Still the same.
Also Sessions Court. Okay. So anyone else? Yeah.
Ma'am.
Sekejap, one by one. Okay.
So I disagree with the statement of yes, he can claim 1.2 million at High Court, because High Court does not hear to civil cases related to landlord and tenant exceeding 1 million ringgit, Malaysia.
So your answer would be B, still Sessions Court.
No. It says that can he claim at High Court for amounting for 1.2 million, right? So yeah, my answer is no. He cannot claim 1.2 million.
Okay. Okay. Anyone else?
Madam.
Yeah.
For A, still Session Court. B, I think the High Court can be claimed because the High Court just stated landlord and tenant. It is about the rental and everything else about between them both. But then if we see the question again, it says for the damage, it is related to property. So I think it can be acceptable in the High Court.
Okay. Anyone else have any other opinion? Shakila, what is your opinion?
Yes, Miss. Same like the Deciman, the previous one. Because it stated that it's nothing to do with the tenant and landlord. It's like stated sue for damages.
Okay.
So he can claim from the High Court.
Okay. So that's all. Anyone else wants to point out their opinion on this? Okay, no one else. Okay. So when we read the question, we read the question again. So this is between Kasut Cantik Sdn Bhd, who is a tenant, and Lim Kiat Sing, who is a landlord. So because this is an issue between a tenant and a landlord, and it is related to a rental agreement. Okay, so for question A, I think everyone agrees that the court that has the jurisdiction to hear the case filed by Mr. Lim is the Sessions Court, because the Sessions Court has the jurisdiction to hear all cases related to landlord and tenant. Yes, so question A, I think no problem. But for question B, so some say that because it is more than 1 million, it cannot be heard by the Sessions Court. It can be heard by the High Court. But some other people say that because the Sessions Court has unlimited jurisdiction, so even though unlimited for cases involving landlord and tenant, even though it is more than 1 million, it still can be heard by the Sessions Court. And then we have a third opinion saying that damages, meaning that it is not something related to landlord and tenant. So that's why it can be heard by the High Court. Okay, so before I choose which of the three is correct, Actually, the word damages inside this question, it's actually refers to ganti rugi. So under the law, if you want to claim something, you said you claim for damages. So these damages does not refer to you destroy someone's house, or so I mean it's not related to some kind of damage, some type of property. It actually refers to ganti rugi. So if you want to sue someone, usually you sue someone and claim for damages. So that's what the damages means in this question. So they actually in this question, because Kasut Cantik wants to terminate the rental agreement 6 months earlier. So when they terminate the rental agreement 6 months earlier, they will cause some kind of damages, Mr. Lim, because Mr. Lim will occur some kerugian because he only gets he only get the salary he only get the rental for 6 months only instead of rental for 1 year. So he will suffer some loss. So that's why he wants to claim. So among answer A, B and C, the correct answer is B, because it landlord and tenant agreement, landlord and tenant situation. So he wants to claim for a loss that he occurs during due to the some loss that he occurs due to the early termination. So it is the Sessions Court, because Sessions Court does have the unlimited jurisdiction to hear all cases related to landlord and tenant. So the one who state about you are the most correct one. Who is the one who state about unlimited jurisdiction?
I think Hadi.
Yeah, I think Hadi also. Yeah, so Hadi, your answer is correct for B. Okay,
Thank you,
so
madam.
everyone agrees with my explanation, or you still want to argue? Okay. Okay. Okay, so we go to the last question, question 2. Anyone else wants to try to answer question 2?
Miss, can I go again?
Can.
Alright. So, sekejap. Alright. Dr. Azmi Sharon is a law lecturer at University Malaya. He was charged with the offence of saying seditious remarks in his weekly column in the Star and is charged under Section 4 of the Seditions Act 1940. And he plans to challenge the Section 4 of the Sedition Act, contravene Act 10 of the Federal Constitution that guarantees freedom of speech. Which court has the jurisdiction to hear this matter? Why? So, Miss, on our group's opinion, it is believed that the High Court is able to resolve this matter because at the moment, if you are looking at it, he is using his freedom of speech as given under Article 10 of the Federal Constitution in remark to the seditious remark that was made in the Star University. If at all that was not being able to conserve, we can also conclude that and appeal to the federal court.
Suara you breaking lah.
Adoy. That was so beautifully said and then it was lagging.
Chill, bro, chill.
I really practiced on that. All right. So in general, he can go to the High Court because he was accused of saying seditious remark. But he's using his Article 10 of the Federal Constitution that guarantees freedom of speech. So the person that said the seditious remark in the Star column. So in this matter, he can go to the High Court. But if needed, he can go to the Court of Appeal and be sent to the Federal Court for further jurisdiction needed.
Okay. Okay. So anyone else have any other answer? Anyone else wants to try? Anyone else? So Shakila, how did you answer that question?
Madam, to be frank,
Hmm?
just now my group just discussing.
Alamak. Lagging juga ke?
Lag.
Alah.
Hujan, Miss, hujan. Baru lepas hujan.
I don't understand this question.
So,
Anyone?
Miss, is it?
Okay.
Sorry, Miss. I just nak tanya satu soalan. Was the answer correct?
Actually,
Almost.
this is a real life story. If you Google, all the facts are not all the facts are correct, but actually, Dr. Azmi Sharum is a real person, and he was under the offence of sedition under Sedition Act. So when he was charged, the case was heard. I think I'm not sure whether in the Sessions Court or the High Court. But when you see the question states that he wants to challenge Section 4 because he said that Section 4 contravenes the Federal Constitution. So if you want to challenge a law saying that the law is against the Federal Constitution, you have to go to court. Yeah, because of this. Because he wants to challenge. Yeah. I also heard all kinds of sound.
Miss,
Mm-hmm.
sorry, Miss. Can you repeat again? The line was lagging.
Wait. Okay. So this question, he was charged. I'm not sure in the Sessions Court or the High Court, but because of this sentence, he plans to challenge Section 4 of the Seditions Act. He said that Section 4 of the Seditions Act is against the Federal Constitution. So when you want to challenge a law saying that it is against the Federal Constitution, you have to go to the Federal Court. You have to go to the Federal Court. Not to hear your sedition case, but to hear your application on the issue of challenging Section 4 of the Sedition Act. So you understand what I'm trying to say? So this case, his seditious case is not heard. You don't have to hear his sedition case in the federal court. But the act, you want to say that the act is against the federal constitution, that matter you have to go to the federal court. Is that clear or is it more confusing?
So which means he don't have to appeal.
It's like,
sorry?
So which means he don't have to appeal.
No. He can ask for the court to not hear his application yet. Maksudnya we call it in English we call in law we call it stay proceeding. Means that okay, yes, you can charge me under the High Court at the High Court, but I want to say that this law is against the federal constitution. So High Court, please don't
Miss.
Yeah.
Sorry, Miss. I'll ask later after you finish. It's okay.
Okay. So it means that the sedition case is not heard in the federal court. The sedition case will be heard in either the Sessions Court or the High Court. But if you want to challenge the law, you said that the law is wrong, you can ask the High Court, stop, don't hear. I want to ask the federal court, is this law valid? Because I say this law is against the federal constitution. So he did get to appeal. He did get to appeal to the. He did get to ask to bring the case to the federal court to challenge Section 4. But did he win? I'm not sure. I don't think so.
Oh, okay, Miss.
So because this is a matter of saying that the law is wrong. So when you want to say that a law is wrong because the law is against the federal constitution, you have to go to the federal court. Okay. So I think yeah, I think he doesn't I think the federal court, not federal constitution. I think the federal court reject his appeal because this section 4 of the Seditions Act is quite a controversial section, and many people have tried to challenge that act at the federal court. But I don't think anyone have ever succeeded in challenging that act. Yeah. So this question, the answer is federal court because he wants to challenge the law. He said the law is wrong. So if you want to say that a law is wrong, the law is against the federal constitution, for issue only you go to. But if you want to hear the case of his seditious case, that case is not heard in the federal court. It still have to be heard at the sessions court or the high court.
So, Miss, in general, what happened?
So, in general, what happened to the case of the Tazmi?
So, Miss?
Yeah.
Yeah, very sorry, Miss. Excuse me, but so he tried to go to the High Court, appealed to the Federal Court, but the Federal Court rejected him. Is it even after he had a hearing in the High Court?
No. The thing is, the case was supposed to be heard in the High Court, but he asked the High Court to hold his case because he said the law is wrong. When someone wants to claim that a law is wrong, for that matter only, the law is wrong, only that matter goes directly to the federal court. It's not an appeal case. It's the original jurisdiction of the federal court. So only on the matter of I am saying that section 4 is only that issue only heard in the federal court. But whether his remark is seditious or not, that one is not heard by the federal court. Do you understand the difference?
Yeah, I think I just got it because after you said that when they rejected it, he challenged the law. That part I got it. I understood really why.
Okay. So he,
but I think in order to know this question, we really need to understand what was that section 4 in the Seditions Act, right, Miss?
Actually, when I write this question, I just want you to focus on the line that I underlined, which the part that he wants to challenge. Yeah. But you guys have gone one step further and actually trying to understand what is section 4 is about. That's why you got confused. Yeah, Deciman. So Deciman, basically it is like that. If you want to challenge the law, you want to say that a law is wrong, you go directly. Yes, Deciman, your conclusion is absolutely correct.
So, Madam, is it anyone in Malaysia or anyone in the world have ever win this case if they challenge the law?
Sometimes I mean people did challenge some laws or maybe some subsidiary legislation, and they did go to the federal court, and sometimes the Seditions Act, if you have ever read the section, this section is very controversial. So it is usually used by the some of our previous government like to use this to capture all the political I mean people who does not agree with their political position. So that's why usually when when people try to challenge Seditions Act, it doesn't work. But for any I mean sometimes when you challenge the law, the court did say that the law is wrong. When they say that the law is wrong, the law is no longer applicable.
So if the law is wrong, then they will directly remove the law, is it? Or they change into the better one?
Yes. Usually they don't. Usually the problematic one would not be the whole act. Usually the problematic matter would be maybe 1 or 2 sections. So those sections are either going to be amended or it is going to be repealed. So it's so either it will be removed or amended to make it better.
Oh, okay. I see. Thank you, Madam.
Okay. Okay, any other question? You don't have to worry if your answer is not exactly like what I explained, because law, in learning law, what you need, what more important is you have to argue. So if you can argue, even if your answer is not like my answer, if your argument is acceptable, I will still accept your answer. That's the easy thing about law. As long as you can argue and your argument is logical, I can accept your argument, even if it's different from my argument. Okay, so don't worry if your answer today is very different from what I informed. As long as you can argue well, you don't have to worry about it. Okay? Okay, so any other question?
No, madam.
Okay. Okay, so if you don't have any questions, so that's all for today. Your class recording, I need to explore first your website, because this is the first time I'm teaching business law at this university, so I'm not familiar with your online portal yet. So I'll explore it and I'll share the today's class recording in your portal. But if you want it earlier, I can also share it inside the WhatsApp group. Okay? So if there is no other question, that's all for today. Thank you.
Thank you, Miss.
Thank you, Miss.
Thank you, ma'am. Stay safe.
Thank you, Miss.
Okay.
Thank you, Miss.
Thank you, Miss.
Thank you, YB Sarish. Thank you, YB.
Sangat berjasa. Tak apa.